Hello, I'm Sue from Seoul Law Group, and we're an English-speaking law firm based in Seoul, South Korea. We're back with another law video today, and we'll do a legal analysis of who is responsible for the Itaewon crowd crush. On October 29, 2022, the popular clubbing district of Itaewon, located in Seoul, experienced a crowd crush that claimed the lives of 159 people and injured 196 others. Witnesses and survivors have claimed that there were very few police officers on the streets that night, forcing civilians to aid in rescue and recovery. And while law enforcement has admitted to shortcomings in their response, the discussion on where to place the blame is ongoing. Apart from determining who may be responsible, there is also the question of compensation for the families of the victims. The legal process to determine compensation is likely to take years, given the time required for a full investigation, prosecution review, and court proceedings. The tragic Itaewon incident begs numerous important questions, such as who is responsible for preventing safety accidents, and how can victims be properly compensated? We will explore these conversations in further detail by providing relevant information. Criminal charges against the crowd that pushed. During the investigation of a crowd crush, it can often be difficult for police to determine who is responsible. Some may place the blame on local businesses and security contributed by the narrowing alley where the incident took place, as well as blocking the entrances to nearby stores for refuge, while others may feel that local officials and police are to blame. The Seoul Metropolitan Police Agency has been looking into citizens who may have intentionally encouraged the crowd to push forward, resulting in the fatal fall. This comes following numerous testimonies that several people in the crowd were encouraging others to push forward. But in the end, the police released the person suspected of being the culprit and were unable to find any other culprits. Since the police couldn't arrest a culprit, the case ended for now. However, there has been a debate about whether the culprit could have been legally punished even if they had been arrested. If a perpetrator pushed the crowd and people got injured and even died because of that push, the perpetrator may be punished for injury by negligence and death by negligence. Even if the perpetrator didn't know their action would cause death and injury, they should have known that people might get injured or die if pushed in such a narrow slope, which means they committed negligence. If the perpetrator knew that their push would cause death and injury, then they might even be punished for murder by willful negligence. Willful negligence means that not exactly intending a certain result, but recognizing and allowing the possibility that the result might occur. So even if the perpetrator did not push with the intention that I want to kill these people, if they pushed with the thought that, people might die if I push, but I don't care if they die, so I'll push, then it is murder by willful negligence. But there are also opinions that the perpetrator cannot be punished even if they push the crowd. The alley where the disaster occurred was only 3.2 meters wide with a slope of 10%, while about 100,000 people were congested in the narrow alley. When the crowd is so severely dense, humans cannot make rational decisions and just move according to their instincts. Therefore, pushing other people in that circumstance is only an act according to human instinct, not an act to harm others. According to this opinion, this incident is a simple tragedy caused by too many people crammed into a small space, not a crime to blame on one or two people. Compensation from the government. The government has decided to provide 20 million won, around 14,010 US dollars, to the families of each victim and up to 15 million won in financial aid to cover funeral expenses. Survivors will also be given compensation ranging from 5 to 10 million won, depending on the seriousness of their injuries. This payment is the same for Korean nationals and foreign victims alike, but this is only condolence money paid by the government, not state compensation. Families of the victims are attempting to take a class action against the South Korean government for state compensation, including the families of the foreigners who accounted for 26 of the victims, hailing from 14 different countries. The provision on which the claim is based is Article 2 of the State Compensation Act. According to Article 2, the following criteria must be met for state compensation. There must be public officials or private persons entrusted with public duties, inflict damage on other persons, by intention or negligence, while performing their official duties in violation of the statutes. When these conditions are met, the government becomes liable for the damage caused. One of the statutes that might be considered to have been violated by public officials is the Framework Act on the Management of Disasters and Safety, Article 20 and Article 25-2. The families of the victims may argue that the tragedy occurred because the public officials in Yongsan District Office and Seoul Metropolitan Government failed to comply with the above provisions. Another statute that might be considered to have been violated is Act on the Performance of Duties by Police Officers, Article 5. The families of the victims may argue that the public officials in the police failed to comply with the provision. This is possible because 11 emergency calls were made before the incident took place at 10:15 p.m. The first call was placed at 6:34 p.m., although police did not take sufficient measures as a response. All of these are only speculations for now because the investigations to determine the cause of the incident are still ongoing. The subject and scope of liability would be determined based on the results of the investigation. However, since the lawsuit for state compensation takes a very long time, there is a possibility that the Korean government would take another measure for the victims and the families, enacting a special law only for this case. There have been cases in which special laws have been made for state compensation for large-scale incidences with many deaths. For example, after the Sewol Ferry incident occurred, the government enacted a special law for the state compensation for the victims and the families of the incident. Criminal charges for government officials. Regarding this case, it is also an issue of whether the public officials in charge can be punished as a criminal. Yongsan Police Station Chief and a few police officers, along with Yongsan District Office Chiefs and a few officials in the district office, were indicted with several charges. The trial started around February 8, 2023. Their main charge is injury by occupational negligence and death by occupational negligence, based on Article 268 of the Criminal Act. Another main charge is abandonment of duties based on Article 122 of the Criminal Act. They were charged for these crimes because they neglected their duty to prevent this accident before it happened, and even failed to deal with the accident after it happened. They didn't have any specific plan to prevent the overcrowding event on Halloween, and there were very few police personnel to control the crowd. Even though some 137 police officers had been dispatched to Itaewon, a significant increase from the pre-pandemic years, they were assigned to monitor crimes related to assault or drug use, not to monitor overcrowding events. The Special Investigation Team searched and removed documents from a variety of local police, fire, and subway operator offices. The investigators explored whether police officers at the scene in Itaewon had responded properly and whether the district police's request for reinforcements had been denied. Criminal charges for distributing Itaewon content. Representative Hong Seok-jun proposed to punish those who circulate photos and videos of the deceased without their consent. The police are also investigating those who deliberately spread false information, as well as requesting the deletion of footage on social media deemed insensitive or inappropriate. According to the criminal law, Article 308, a person who defames a dead person by publicly alleging false fact can be punished for defamation of dead person. Already there have been a few people arrested for this crime for defaming the victims of this incident. But there is no law to punish a person who defames a dead person by publicly alleging true facts or sharing photos and videos of the deceased, which is why Hong Seok-jun proposed to make a new law to punish the people who were doing that. Following the incident, the Korea Communications Standards Commission deleted 56 related posts and blocked 48 posts. Many of these are videos and images of the incident without a warning, while several others are related to the discrimination or belittlement of the victims. On both major domestic and foreign social media platforms, 116 posts were deleted as of early November 2022, with that number expected to increase. Illegal extension buildings in Itaewon. A pink temporary wall of Itaewon's Hamilton Hotel has been labeled a potential cause of the disaster. This is because the wall narrows what was once a 4-meter wide alleyway to 3.2 meters. Additionally, it is known as a trick facility that evades building law regulations. Hamilton Hotel has already received a correction order twice and has also been charged for a lounge bar illegally added to the north side of the building. As a result of the investigation by the Ministry of Land, Infrastructure and Transport, it was confirmed that among the buildings near the accident zone, unauthorized extensions built 9 years ago have not yet been taken down. For example, in 2013, it was discovered that the Hamilton Hotel had added 78 square meters of light steel frame and glass without permission to the first and second floors of the building. However, despite this incident taking place nearly a decade ago, no measures were ever taken to correct this illegal construction. Although this extension does not directly relate to the Itaewon incident, it demonstrates a lack of official crackdown on such extensions. The Seoul metropolitan government has since taken a firm response in regard to illegal construction. They aim to continue strengthening crackdowns on illegal buildings in densely populated areas where safety accidents are high risk. Criminal prosecution measures, particularly toward the Hamilton Hotel, will likely be enforced, leading to swift demolition measures. Similar case, Sewol Ferry investigation. On April 16, 2014, the Sewol Ferry sank during a trip from Incheon to Jeju Island. The Sewol Ferry incident is one of the worst maritime disasters in modern Korean history, with the final death toll standing at 304 out of 476 passengers. Of the deaths, 250 were second-year high school students. This tragedy has been blamed on a combination of illegal redesigns, overweight cargo, a lack of crew experience, and lax government regulations. To make matters worse, it is believed that private fishing vessels were able to rescue more passengers than the Korean Coast Guard, bringing up the ultimate question, who is held responsible? The Sewol Ferry Disaster Special Investigation Team saw 11 people, including the captain of the ship, brought to trial under potential charges of murder by willful negligence. The prosecutorial team interviewed a total of 201 suspects and witnesses, as well as raided 17 different government agencies for evidence. The Sewol Ferry captain escaped first without helping passengers who had been told to stay on the ship, waiting for a rescue that never came. As the captain of the ship, he had the duty to protect his own passengers' lives, but he chose not to do so, even though he knew that the passengers might die if he didn't perform his duty. Although he didn't directly drown the victims himself, when he didn't do what he was supposed to do and let them die, the law considered it the same as murder, so he was found guilty of murder by omission and sentenced to life in prison. Although the captain was the only one who was found guilty of murder, other crews of the ship were found guilty of death by abandonment, not murder. Abandonment is a kind of crime in which a person has a duty to help another person, but abandons that person without fulfilling the duty. For example, the parent has a duty to help and protect their child, so if a parent abandons their child, they are guilty of abandonment. If the victim dies because of abandonment, then the crime becomes death caused by abandonment. Also, the inspector and the team captain of the Coast Guard who arrived first at the scene of the accident were found guilty of death by occupational negligence and sentenced to 3 years in prison. Much like Itaewon, the Sewol Ferry incident found it difficult to place criminal charges or to enforce more severe charges on suspects. In addition, records and documents of what happened on that tragic day are difficult or now impossible for citizens to access. While this all seems unfair on the surface, there have been a few steps forward. For example, many new laws have been passed which build safety conditions that will hopefully prevent such a tragedy from happening again in the future. This may not be consoling to everyone, however, as the government and investigative agencies seem to limit the moral discussion at the heart of such tragic situations. Well, I hope this video was useful for you. If you have any questions, let us know below in the comment section, and you can find more information on sewolLawGroup.com. Don't forget to like, subscribe, and turn on the notification bell for more Korean law videos, and we hope to see you next time. Bye.